I'm Michael Popok, and welcome to a special edition of Legal AF After Dark, the Michael Luttig edition. I had the privilege and honor of interviewing for the Meidas Touch Network the preeminent scholar of our time related to constitutional law and the presidency, and that would be Michael Luttig, former appellate federal judge. He was a witness for the Jan 6 committee. He's written numerous amicus briefs to the United States Supreme Court, including on the 14th Amendment, Section 3 issue. He was a legal advisor to Mike Pence and helped guide him to the right decision not to overthrow democracy and to certify the election. During our hard-hitting interview, far-ranging, unfiltered, Judge Luttig and I talked about, in this clip that you're about to see, the D.C. Court of Appeals decision finding no presidential immunity. I'm getting Judge Luttig's view on that, not just what happened, but what happens next and how that impacts the other appeals that Donald Trump is likely to take, including next week, and the trial setting for the various cases, and whether, and Judge Luttig answers the question, whether the Supreme Court's going to take this appeal at all or not, or leave it undisturbed. The D.C. Court of Appeals decision, unanimous that there's no presidential immunity against Donald Trump, and let this case, the D.C. election interference case, get back to Judge Chutkan to be set for trial before the election. Take a listen. Here's a segue that came right out of a Kavanaugh question into our next topic, which was, again, I think a misreading of the 14th Amendment, Section 3. It doesn't say trial, indictment, and conviction. It says engaged. And he said, well, what if your guy was indicted and convicted of insurrection? And we all know, just for our audience sakes, that that's not part of any of the 91 felony counts against Donald Trump. There are many counts against him for obstruction of justice and conspiracies around that, Espionage Act and that type of thing, but not for the crime of insurrection. There's things that are analogous to it, but not exactly. And so Mitchell, had to concede, which he did a lot of conceding, as you noted, when he was thrown life preservers, life rafts, he sort of dodged them and said, oh, that doesn't, like you said, that doesn't really help our argument. But he did take the moment to be at least partially consistent on the Trump side by saying, well, yes, then I think we would be banned, which I don't think is consistent with the argument, but we have immunity. That takes us to Tuesday, which in any given week would have been the most momentous decision or issue event of the week in this area that we've been talking about, with the three-judge panel, Pan, Childs, and Henderson of the D.C. Court of Appeals ruling 3-0 in a really, from my perspective, magnificently written dismantling limb by limb of every one of Donald Trump's major arguments. You listed 7 or so that were in play in the Supreme Court for the last segment. There was at least 7 or 8 major arguments that they took on one by one in their decision making, starting with jurisdiction, interlocutory jurisdiction, whether the court had jurisdiction at all. It spent a fair amount of time on that. I think that was the Judge Child's position, and then got into the heart of the matter on impeachment, whether there's an impeachment prerequisite to criminal indictment for a president or not, structural separation of powers type immunity, and the rest. So my question for you, Judge, is, having now gone through it and read it, and understanding the timetable that's now been set up by the D.C. Court of Appeals, with Donald Trump having to give a notice of an appeal or try to take an emergency interlocutory appeal up, writ of cert up to the Supreme Court by the 13th, which is coming up. What was your takeaway from the decision, and what do you think John Roberts and the rest of the Supreme Court do next with this appeal? Do they leave it and say, we're not taking this appeal, everything looks fine here, we'll see at the end of the case? Or do they insert themselves in there again? And is there a grand bargain? If they're going to give him the ballot, are they going to find that, not just for Donald Trump, but for our constitutional republic, that there is no immunity from criminal prosecution for conduct as indicted when you're a president?
Michael, let me begin by just addressing one last thing that you said before you asked that question about the 14th Amendment argument. Jonathan Mitchell, on behalf of the former president, did not concede anything. This is a technical point, but it's of great significance for the Constitution and for the Supreme Court. As I had said at the beginning, he was the most honest advocate ever to appear before the Supreme Court. But the listeners need to understand that the Supreme Court believed that they were helping Mr. Mitchell. And Mr. Mitchell refused to be on record as gratuitously accepting those gratuitous offers of help, and explained repeatedly to the court directly that, no, Your Honors, that does not help us. Now, to the immunity case. At the same time, a block or two away from each other, that the Supreme Court was engaging in the argument that we just discussed, the D.C. Circuit Court of Appeals decided, not as important, but almost as important, a fundamental constitutional issue related to the presidency as it did. It did not flinch. There was never an argument, there has never been an argument that a former president is immune from prosecution for criminal offenses against the United States of America after he or she leaves office. Literally, there is no argument that could have been made under the Constitution of the United States for that proposition. That's not to take credit away from the D.C. Circuit. It's to give the D.C. Circuit the credit that it's due. It professionally, as anyone could ever do from the federal bench, destroyed the arguments that were made by the former president, down to this point. So I was asked at the last minute to please come on one of the television networks and talk about the immunity decision. But I was asked to come talk about the 14th Amendment case that was to be heard a day later. But I had just seen that the D.C. Circuit had rejected that the president had immunity for precisely the criminal offense that gives rise to his disqualification under the 14th Amendment. That is, that the D.C. Circuit, by terms, said the president would not be immune from criminal prosecution for having attempted to remain in power in violation of the executive vesting clause of the Constitution and preventing the peaceful transfer of power. So I'll pause briefly just to let all of us think about that. So the D.C. Circuit, essentially one day before argument in the Supreme Court, held that the former president, of course, would never be immune from prosecution for the act of trying to remain in power beyond his 4-year term when the American people had voted for his successor, Joe Biden. of course, the D.C. Circuit was not addressing the totally separate question of whether the president had engaged in insurrection against the Constitution by doing that act or those acts. But it was not lost on anyone, first, by the D.C. Circuit, but second, by the Supreme Court of the United States, that the D.C. Circuit had just held what it did as to the 14th Amendment disqualification question. Now, you ask, where does the immunity case go from now? Well, by Monday, we'll know, because technical jargon, the D.C. Circuit stayed its mandate only until Monday, and only until or unless the Supreme Court itself issued its own stay, which means we'll know Monday or Tuesday at the latest whether what the Supreme Court's going to do or might do. I don't, of course, have any more insight than anyone else does, but I believe that the court might well decline review of that immunity case, because the Supreme Court knows that it would never in a million years reverse that decision. I don't believe that there is a single justice on the Supreme Court that disagrees with the D.C. Circuit immunity decision. At the same time, the D.C. Circuit understood, as does the Supreme Court of the United States, that if the Supreme Court takes the immunity case, it increases exponentially the likelihood that the former president will not be tried before the 2024 presidential election. Now, courts are appropriately to be unconcerned with that kind of political consideration, but not in this one instance of all, where a president of the United States, for the first time in American history, is to go on trial for crimes against the United States of America. In that one instance, the Supreme Court has a responsibility to the nation not to unnecessarily delay that trial until after the election.
Yeah, that's what I wanted to ask you. I mean, given the timing, so it sounds like to me you think there's a good chance that there's not 4 votes to take it up through John Roberts as that's kind of circuit judge administrative role that he would serve here, and to take it up because of the analysis, the airtight and waterproof analysis, I think led by Judge Pan, although it was per curiam in the decision. And then if they did take it up, though, your fear is that they set their own timetable. And whereas the lower courts, the D.C. Court of Appeals in another case recently involving the gag order, said it was important to the American electorate to understand whether they were voting for a convicted criminal or not, my paraphrase, before November 5th. But you don't think, we know the Supreme Court's view on political questions and interfering or getting involved with that. Although by taking it up, if they really aren't going to reverse it, we then lose that period that's necessary to try the case with Judge Chutkan. She's ready in May, June, July, or whenever it is to get that federal case up and running. So, do you think there's you said I don't think there's a single justice. I think to take what you just said that would overturn this. So do you think they're going to, we'll know better next week, but do you think they're going to do that, or they're going to leave this in place and move on as part of some sort of grand bargain about letting it be on the ballot, but you're not getting, our constitutional republic is not going to give a free pass to the future occupant of the Oval Office for potential criminal conduct while he's in office, just because he happened to be the president?
Well, Michael, I'll answer that question within the exquisite context, if you will, of your suggestion of a grand compromise or bargain. The courts of the United States, and especially the Supreme Court of the United States, is obligated by oath never to strike a compromise on any case, let alone between two pending cases involving the President of the United States of America. That would be insidious for any court even to think about that. That's really, in sum and substance, why I've said that in my view, the Supreme Court had an obligation to decide the question that was presented to it. And that's not, of course, it's not to say how the court should decide it. I'm indifferent as to that question, as all of us should be. Our view should always be the Supreme Court is the guardian of our Constitution, and they protect the Constitution and thereby us. But in every instance where they're required in their protection of us and in their service to the Constitution, that they are called upon to decide a great question of the moment that is relevant in the moment, it's timely, and it is presented, that they have a responsibility to decide that question. And I don't myself entertain any of the political arguments for the court refusing to decide the question. And I will not acknowledge that it, in any way whatsoever, that if that's what they do, that is a legitimate off-ramp to decision. As I said, I believe the Supreme Court, appropriately aware and sensitive to the timing of the president's trial, will deny review of the D.C. Circuit opinion. And all I'll say is if they don't and they take up the case, that will be telling of something. Okay.
Yeah. That's great, Judge. That's the kind of information, at least, that we can use, our audience can use to evaluate what they see next, and we'll see it as early as next week. Well, there's an example. When we have a powerful guest like Judge Luttig, we bring him to our audience the only way we know how, without blowing smoke or sunshine, right here on the Meidas Touch Network and on Legal AF, our podcast we do on Wednesdays and Saturdays at 8 p.m. Eastern Time on this YouTube channel. You're already here. Don't change the dial. And then on audio podcast platforms of your choice. If you know all about Legal AF, welcome back. We appreciate you. Take that clip, send it off to people in your life, and ask them to join our journey as part of theirs. If you have no idea what I'm talking about, that was an example of Legal AF, our curated podcast at the intersection of law, politics, and justice, and we welcome you to join us. So until my next hot take, until my next Legal AF, this is Michael Popok reporting.
Love this video? Make sure you stay up to date on the latest breaking news and all things Meidas by signing up to the Meidas Touch newsletter at MeidasTouch.com/newsletter.